signed. Committee Room 21, 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 signed. Committee Room 21. 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 Sound. 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 Committee Room 21. Sound.
The meeting is open to the public. Welcome, members excuse me, to the 15th meeting of the Committee for Finance in the 2027 mandate, 22 to 27 mandate. This will be broadcast throughout Parliament buildings and online. Anyone who is in the gallery can access Assembly Wi-Fi, but please keep your devices muted or under airplane mode. It is not permitted to take photographs or videos of any proceedings. Agenda item 1 is apologies. Apologies have been received from Philip Brett, and we have one member joining us remotely.
Can we just check and make sure that Mr. Carroll can hear us?
I can indeed.
Okay, and you can see us okay?
I can, yeah, can you?
Great. Okay.
Hear me okay, yeah?
Working.
We can hear you, Jerry, yep.
Yep, thanks.
Okay, obviously indicate when you want to ask a question or come in. Agenda item 2 is declaration of interests. Members are obliged to declare any relevant financial or other interests at each committee meeting as applicable. Have members any relevant interests to declare? Okay, and obviously you can declare an interest as we go along should you need to. Agenda item 3 is executive legislation, written ministerial statement, which is of the executive legislative programme. And at page 6 of the meeting pack, the First and Deputy First Minister led a WMS on the executive legislative programme for 2024 for the remainder of the calendar year. Relevant items for this committee are the normal budget bills as part of the annual cycle and a financial provisions bill, which may include provisions which would otherwise form a separate financial assistance bill by the Department of Economy. Mention is also made of a fiscal council bill on a permanent statutory basis. There is no mention of the marriage bill or any divorce legislation. There also wasn't any there wasn't any mention of the legislation in relation to registration of stillbirths.
So we will hopefully hear more of that as we go on. But we can check back with the department.
It would be useful, I think, if people are just to check back on relation to status of the Fiscal Council bill and the bill re stillbirths, if people are content with that.
Yeah, I just
Anyone else
support
wants to come in? Steve Aiken?
Yeah, just to support the sort of the chair on the Fiscal Council bill. We've been told for some time that it's in the process of, so maybe an update of where that is in the legislative process would be quite useful. Thank you.
Okay.
Just to clarify, is that registration of stillbirths different from the stat rules that they put through in secondary legislation?
This is the stat rules that we were expecting legislation on, so the fact it's not been flagged up, but we haven't had an updated programme for secondary legislation yet. We've been asking for that for quite some time. We'll push that again because it just means we have a better idea when to expect things.
Surely that's the negative resolution piece for September.
Yes.
So is it not automatically?
It's not going to be. It's not a primary bill. We've
Okay.
been told it's going to be secondary legislation. Okay. So it would just be ideal if we could get timescales for that, because we know we still haven't had the SRs to allow us to go through to September. We're still waiting for that.
Oh, right.
So we need that done fairly quickly.
Yeah.
So we'll push to get those timescales all lined up.
Okay. Would anyone else want to come in on the legislative programme? No. Okay, in that case, we will note that, and we are seeking an update from the department on timeframes, particularly in the Fiscal Council. Agenda item 2 is levelling up funds and officials' appearance before the devolved administration committees. Members, on the 8th of May, we agreed to write to Michael Gove, Secretary of State for Levelling Up Housing and Communities and Minister for Intergovernmental Relations. This followed a departmental briefing on levelling up funding designed to replace EU funds and the committee's ongoing efforts to secure briefing from UK departmental officials. Members, you will be surprised to note that in the days after last Wednesday's meeting, we were advised by officials of the relevant department that they could not get our correspondence over the line, quote, before the House prorogues. So saved by the bell. I presume that's why Rishi Sunak called the election when he did, was the correspondence from the Finance Committee. But obviously we can pursue this when there is hopefully a new government in London, whatever we think about said government. Steve Aiken, you want to come in?
Yeah, just to note, obviously we heard the Tories' view on introducing national service, and they were going to use the money from the Levelling Up Fund and from the Special Projects Fund. I think sort of a large degree of this quiet because so much of those monies had already pre-allocated to not just to Northern Ireland but other areas as well. Maybe something this committee could note and make a formal record of is, and maybe you have to sort of canvass everybody here, but our concerns that there was going to be using those funds for that particular purpose when in fact they should be used for what we were told they're going to be, which was replacing EU funds that have gone.
Well, I think it's probably worth. I mean, we could give very, very strong views with that policy. I think we all could around the table. Obviously, I suppose one thing to say is that's just policy by a party which is running for election. I would say in parenthesis politically. I hope they don't get elected, but. I think you put those comments are on the record, yeah. And we will, should that be a policy that is pursued, hopefully it isn't, in my view, after the general election, we can pursue that unless any member, but it is on the record, and we can obviously touch on it post-election should that be required, unless any member wants to add.
Just one quick follow-up.
Okay.
Obviously it's the quantum that is the issue, bearing in mind all the conversations we've had about additional funds going direct, impact on local government and the rest of it. For something that wasn't supposed to be in scope is now very definitely in scope, so it doesn't matter which government comes back. I think there's...
I think it's a manifesto thing. As far as I'm aware, this is not British government policy yet, and hopefully it never will see the light of day. So I think, so while I share in very large capital letters the concern about that policy, which I think is utterly preposterous and ridiculous, particularly in relation to this region, I'm not sure we should spend that much time debating manifestos from parties that may or may not be.
Chair, if it's helpful, because
we have time to do that afterwards.
Because the correspondence went in, our view would be, unless the committee decided that they didn't want to send it, it remains there. We will reissue it to whoever occupies that office,
and it'll be
assuming that
yes.
office exists post.
That is the thing. They could that department could be abolished or renamed on July the 5th, and that wouldn't, you know.
But the members will recall from the briefings we've had, there is that pressure that if the SPF is still there, talks about what happens next year, need to start very soon. So that's how we're holding this correspondence, that it'll reissue as soon as there's a new occupant who's relevant.
Okay. So
That's a metaphorical thumbs up from here.
members, that's to note then at this stage, unless anybody else wants to say make any point about it. The next agenda item was something that I had spoken to the clerk about, but it is now moot because I believe it's been published already. So we were going to seek agreement to ask for Nick's guidance in relation to the pre-election period, which we are now in, and obviously this came up at First Minister's questions to the First Minister yesterday. So we will have an opportunity to scrutinise that. Can I suggest it's maybe worth putting in people's packs for the next week, and we can and members can raise any queries or questions, and obviously we will have the head of the civil service before us on the 26th. So any issues with that can be raised at that point. Agenda item 4, draft minutes of the meeting held on 22nd of May. So members, page 11 of the meeting pack are the minutes for the meeting on the 22nd of May. If people are content, I will sign those minutes.
I just want to put on record our thanks for helping facilitate probably the longest distance Finance Committee meeting that there's been in the Northern Ireland Assembly so far. And thank you very much indeed for Peter particularly sort of arranging for the comms links and making it work. It was actually clearer from there than I've had from here, if you know what I mean.
Technology worked for us, Chair.
Yeah. But thank you.
Okay. Thank you very much. Put that on the record. Next item is matters arising. Item 5.1, Department of Finance, is the bids that have come in from page 23 of the meeting pack. The department has provided committees with copies of RDEL, CDEL and FTC, meaning Financial Transactions Capital, bids from various departments ahead of this is TO, not all departments, this is just TO's bids. If anybody has any comments that they wish to make.
Just a quick one. I wouldn't mind a bit more information on what the civil contingencies bunker is with an extra £1 million added to it. Bearing in mind some of the things we've had over the COVID and the fact that the civil contingencies took a long time being set up and the linkages and what it is. Just be interested to know what the civil contingencies bunker is. Is it actually a physical thing, or is it actually improving its IT and its staffing levels?
I would also like to know what the Centre of Government transformation bid was, and I'm not clear if it was successful or not. But it would be helpful to know what the Centre of Government, because it also relates to work around the civil service, and obviously that kind of touches in our department, our bailiwick. If anybody else wants to raise, Paul Frew.
Yeah, can I just add then, why then is TO bidding for Chief Scientific Advisor and Team Research? I've always had the impression that Chief Scientific Advisor seems to come under the Department of Health. It'd be interesting to know. Now, it's not a lot of money, of course, but whether, of course, the Scientific Advisor is for Northern Ireland, but I always thought they come under the Department of Health. So just to clarify that position.
Yeah. Okay, we need to see clarification on that. Okay. If members are content, the next item is an update on the interim fiscal framework. Members, page 26, of the meeting pack, the department has provided a briefing on the interim fiscal framework, which was signed by the Minister of Finance on the 21st of May 2024. Members will recall that officials were able to brief the committee on this at last week's meeting. I think we got a fairly full briefing on it, I would, so if members are content to note that briefing and seek updates, I would like a specific update as part of seeking. I would like a specific update on the public sector transformation board. I keep calling public sector transformation board. And Joanne did mention it. We did ask her last week, and I think her expectation was that, and apologies if I'm misquoting her, but this summer, the expectation was to be set up this summer.
Yes, Chair. Aspects of the finance package are contingent on it, so the release monies. Yes.
Okay. That is fine. Anyone else wish to come in on that? I'll content to note. Next is the urgent WMS from the Minister of Education, which is on early learning and childcare measures. So the Minister, at page 52 of the pack, the Minister of Education laid an urgent ministerial statement on early learning and childcare measures on Thursday, the 23rd of May 24. This is to note, this WMS, unless any member wishes to make any comment or further information. Deputy Chair.
Pardon me, thank you, Chair. I think that it's good to see that coming out as a ring-fenced item out of the Finance Minister's budget statement, put through the Executive quite quickly and agree on a package. And I wonder, is it something that the committee could look at the other ring-fenced items and see is there any timescale for plans to commit to those from any other departments? Sooner the things that were listed by the Finance Minister in the budget statement.
I think that's a reasonable thing to do. Do you mean writing to the Minister of Finance to find out if there are?
Potentially, yeah.
I would be content to do that and see what if there are specific timescales and parameters for delivering on them. If people are content with that, I would also suggest. I would say, in my capacity as opposition leader of the constructive opposition, I would commend the Minister of Education for, though I would wish more money was committed to. I think this was a positive step forward, and I think it's a start, albeit it doesn't answer. It doesn't come close to what we need to do, but it is it's a useful start. So I would acknowledge that. Put that on the record. Next item is 5.4, which is the Hansard transcript of the Senate in Wales, their debate of the legislative consent motion. Members, at last week's meeting, members noted that the Senate did not agree to that the provisions in the Data Protection and Digital Information Bill should be considered by the UK Parliament. Members requested a copy of the Hansard transcript of the Senate debate, and that is provided. Members of the Welsh Government and the Senate expressed concern that powers currently exercised by Welsh ministers would be removed and exercised at a UK government level. There were also concerns about the impact of the bill on relations with the EU. The bill is at report stage in the Lords, and at present it is unclear if the bill will continue in the next Parliament, as public bills can be carried over. That's to note. I would just put one comment and concern on the record, which I haven't done as yet in previous briefings on this. There is a specific concern around potential divergence in terms of data protection rules and what that would mean for lots of cross-border activity. There are lots of, obviously, services business, but also sports clubs, community groups who have to share data on a cross-border basis, and divergence from that. Anything that this law does that would make that potentially jeopardise that is something I would have a concern about. But that's me putting that on the record. Unless anybody other member wants to come in, Steve Aiken.
Just a very quick one. Two things. One, this is an area that we're going to look at from the Commonwealth Parliamentary Association, and I think we're taking that as for an action here within the Assembly. But one of our team, I think namely me, is going to be on the team who's going to be looking at that. So if you're content, if we can pass that on to the CPA here as well. Second one is, and I noticed what the Chair's comments are about potential cross-border issues and the rest of it. I think this is something that might be worthwhile our committee just asking the Windsor Framework Committee to note as something of concern that's likely to come down the route as well. There's some things that are on an action plan or an action grid, and that might be useful. So just as a heads up, that was coming. And a declaration of interest I sent in the Windsor Framework Committee.
Chair, the other thing I would flag up to members is we'd already started a little bit of preliminary work on this. So I'd been in touch with Ofcom because they have taken on new digital responsibilities. this is not entirely them, and they've pointed me towards the local information commissioner's office. So I have made contact there and would plan to get their view on this. Because as you've said, not all bills will fall. Some public bills can be carried over should a new government choose to do that, because this is obviously a government bill now. So there's a bit of a waiting game, but I don't think it would hurt to get that information from the ICO, just as to what their take on this is and what their role would be. If members are content to do that.
Content to do that, yeah. So that is useful. Agenda items 5.5 and 5.6 are Hansard transcripts from the Fiscal Council and the NERI/Pivotal Joint Briefing. That's the Nevin Economic Research Institute / Pivotal Joint Briefing on the Draft Executive Budget 24-25. That starts at page 67 of the meeting pack, and members, if you're content to note these transcripts, unless anybody has any comments. Yes, go ahead.
Yeah, sorry, Chair, just as we don't have it set out in the agenda specifically to the budget anywhere, just wanted to make the point from the contributions yesterday, it seemed very clear that our own Department of Finance is the only department that has adequately briefed the committee, and that very much came through from everyone. I was just sort of taking a note and ticking off, and there was a whole array of things, frustrations from different committees, but it was just Department of Finance. So whatever we want to do to acknowledge feedback on that, I think it's important to note.
Yeah, I think that is definitely worth putting on the record, and obviously multiple other spokespeople and committee chairs wanted to bring made that point around scrutiny. Steve Aiken.
Yeah, I thought it was disappointing yesterday. We, as a finance committee, produced a framework document for the other departments to fill in, so to make it easier, so that everybody would be able to understand for the same thing. It's been referenced by the Fiscal Council. It's been referenced by everybody who's come to, and only the Department of Finance did it. I think it's something we should highlight as a concern from this committee, because how can we do scrutiny unless we've got the information? We haven't got it.
And not only how do we do scrutiny of the entire budget and its processes, how do the individual committees scrutinise their own departments? It's just bonkers stuff. It seems to be worse now than ever.
Yeah, it is a huge problem, because we're now going to be in this slightly farcical situation where they will be getting. Now it's not pointless, because they still need the information about what the financial bid was, but the Justice Committee, the Education Committee are going to be getting briefing technically about a budget that they have already voted for or against, and it will be useful information for them in terms of their own deliberations going forward. But obviously it is a slightly preposterous activity to scrutinise a budget which has already been endorsed. Okay.
Not by everybody.
But certainly not by everybody. By that I was speaking about in an assembly context. Clearly, I didn't endorse, neither did you. I would just say, since we're on that, I'll use this since the deputy chair correctly raised it, to say people will be aware that in my capacity, I have two sort of statutory rules on a day like yesterday, where I was speaking both as I'm obliged to speak to give our collective view to the extent that we have one, on the scrutiny we've done on behalf of committee, and as leader of the opposition. But the deputy chair agreed to give the committee's view, which was most appreciated, in part because they're time limited speeches, and I wouldn't have been able to do justice to either the committee's role or to my own, as it were, political role. And that's something I'll be suggesting going forward to the Procedures Committee that could be looked at. One MLA can't speak twice, but I just wanted to say thank you on the record to the deputy chair for filling in for me in that regard yesterday. Okay, is there any other comments on that? Clark?
Chair, just with reference to the comments members have made, it might be worth, if the committee wants to, writing to the Finance Minister to highlight the fact that the template is there, and that there should be advocacy of all departments using it. What it allows committees to do is have a uniform basis on which to do their scrutiny.
Can I suggest, it might be worth, to that end, writing or sending it to the chairperson's liaison group as something that can be discussed in terms of the various groups and their various committees. Okay, that is that. So next item is the Government Resources and Accounts Northern Ireland Act 2001 Estimates and Accounts Designation of Bodies Order 2024. At the meeting on the 15th of May, the committee agreed that it was content with a proposed statutory rule to provide a list of designate bodies for inclusion in departmental estimates and accounts for the year ending 31st of March 2025. The rule has now been formally laid and is subject to negative resolution procedure before the Assembly. The Department have stated that there have been no changes to policy content since the SL1 was submitted to the committee. Full details and background to the rule can be found in the correspondence from the Department starting at page 106 of the meeting pack. The end of the statutory period for this SR is 30th of June 2024. The Examiner of Statutory Rules anticipates reporting on this rule in her next report, due to be published on Friday, 31st May. Members are asked to consider this rule subject to the Examiner's report. If any issues are highlighted by the Examiner, this will be brought to the committee's immediate attention. Members, are you content with the statutory rule subject to the ESR report? Hearing no dissenting voices, so I'll put the question that the Committee for Finance has considered SR 114/2024, the Government Resources and Accounts Northern Ireland Act 2001, Estimates and Accounts Designation of Bodies Order 24, and subject to the Examiner's report, has no objection to the rule. Agreed? Agreed. Okay. And the next agenda item is civil law reform oral briefing from the Departmental Solicitor's Office. So if members are content, Hansard will report this oral briefing. Yes. Members, there's a clerk's memo at page 121 of the meeting pack, and at page 124 of the meeting pack is a briefing paper supplied by officials for this session. So members, the DSO officials will brief the committee on gender recognition and other civil law reform, including defamation. So welcome to the meeting, Michael Foster, Head of Civil Law Reform, and Martin Tyrrell, Policy Advisor in terms of civil law reform. I will myself, just at the beginning, declare an interest, which is that I was in the previous committee which considered the Defamation Act, and I have myself, as a representative and a citizen, had some encounter with the law on defamation. As I put that on the record, as not that it's necessarily an interest, but worth being putting it on the record. So we would like the officials to make an opening statement.
Thank you very much, Chair. May I assist the committee just to set out briefly the sort of breadth of our remit?
Yes.
We have responsibility for civil law reform, and that's distinct from civil law. Civil law being the responsibility of all of the various departments here. It used to be housed under a separate directorate, which was the Office of Law Reform, but that since 2007 has been housed within Departmental Solicitors Office as the Civil Law Reform Division. And we essentially advise ministers and senior officials on a range of different law reform matters and proposed changes to the law, which can come from a variety of sources. They can be initiated by ministers, or they can be initiatives that have come through, for example, Westminster or other legislatures which may have relevance to this jurisdiction. But in the main, our responsibilities tend to lie in defined areas, and those have tended to be in relation to marriage and civil partnership, and the committee will know that we briefed the committee recently on that. Divorce, family law, which includes parentage, parental responsibility, and things like that. Gender recognition, the law of tort, which of course includes defamation, land law, and private international law. Those tend to be the main areas that we would cover. Some of those are tied to other departmental functions. So, for example, on the marriage and civil partnership, gender recognition side, we have a very close linkage and relationship with GRO. And on the land law side, we would have a linkage to land and property services. But we occasionally would field queries where the lines of departmental responsibilities are somewhat unclear, and they tend sometimes to fall to us to take a view on, and sometimes we will progress those if we have either the resource or the knowledge to do so. We also tend to be involved in occasional judicial reviews where there are challenges to the existing law which may have a law reform angle to it in due course. And over the last number of years we've been involved in a number of those, most recently on things like parenthood and parental responsibility, where there are active cases within the courts. We've also, as the Chair referenced there, become involved in private members' bills from time to time, and the most recent one was, of course, Mike Nesbitt's bill on defamation in the last mandate. I sit on the Civil Justice Council and the Family Justice Board, as well as a number of other bodies like the Domestic Violence Strategy Board and the Mental Capacity Implementation Group. And we have a very, very wide range of stakeholders across a whole range of different policy areas. And of course, things like AQs, correspondence cases, and etc. will tend to come to us for advice and taken forward. At the moment then, we have obviously a number of active areas of work. I don't want to dwell too much on marriage and civil partnership because we've already briefed the committee on that. But that is our current priority in terms of legislation. And the executive paper has been circulated to ministerial colleagues. And we hope to work up instructions to Legislative Council before the summer so that we can begin drafting on that particular bill, and that follows on from the update which we gave you last month, and that has progressed to that extent now.
Just on that, so that is, you're waiting on the report back in order to start drafting. This is on marriage age, and so you hope to start drafting sort of in the next month or two?
We hope to have the instructions finalised and sent to Council by the summer, and then Council will determine in terms of their own particular resources what the time frame for drafting will be. But I had a meeting with First Legislative Council last week, and he was quite confident that they'd be able to start drafting pretty soon.
Great.
So, as well as marriage and civil partnership, then we have had a range of other work recently. Defamation is one of those, where, as you will know, Chair, the private members' bill was passed at the tail end of the last mandate. That took up a considerable resource within our office in terms of managing that, and obviously one of the outputs of that was a statutory review of the legislation. And that has taken up quite a bit of our time in the last sort of 6 to 9 months, where we undertook a consultation exercise and a stakeholder engagement exercise. And the analysis of that is now complete, and advice is with the Minister at the moment. And the proposal is that a report on that will be available hopefully within the next few weeks, both for this committee and also for laying at the Assembly. And that will cover a whole range of different issues, not just in relation to an analysis of the impact of the 2022 Act, but also covers other recent developments in relation to defamation law. And as I say, that is currently with the Minister for her consideration.
And that was I believe that was, correct me, that was I think a clause that went into the bill when we were considering it, that there would be a report.
That's quite right, yeah.
Okay, so that will be laid before the Assembly, did you say before recess? Or will it
yes,
be?
It will be before recess.
Okay.
It's the provision was Section 11 of the Act, which was 2 years from the Royal Assent of the Act. Royal Assent of the Act was in June 2022, so we hope to lay it this month.
Well, I'm sure we can ask questions on that and other things. That's most helpful. So obviously, members, as always, including those who are joining us remotely, indicate to the clerk should you wish to come in. Just on a few different things, and I won't divide the briefing up, so members feel free to ask across the range of civil law areas that Michael outlined. First of all, in relation to gender recognition, where are we, and what are the timelines for reform of GRC? Should that be a policy that is agreed? As I understand it, I don't know if that's been agreed at executive level.
It hasn't. We're quite a bit behind that, Chair, in relation to where we are with this. I mean,
say GRC is Gender Recognition Certificate for the purposes of the record.
Yeah, I mean, the reform of the Gender Recognition Act is a huge policy area. I mean, I should say that my office is currently resourced by what you see in front of you.
Yes,
this is the extent of our resource. Although we've a new member of staff joining us actually this week on a part-time basis, which will be
scared of the workload if they see this evidence session. They'll think, "God, there's a lot to do."
But she is actually watching at the moment, I think. So I hope she's still there when we get back.
And the contract is the important thing.
Essentially, in this area, we've been adopting a watching brief. I can only put it that highly. There's been a number of developments over the last sort of 6 to 7 years in this area. England and Wales were the first ones really to commence a review of the Gender Recognition Act, which applies on a UK-wide basis. And that review pointed initially back in 2018 to quite significant reform of the Act, but developments on the political side overcame that, and that policy has largely been put on hold in England and Wales in terms of the sort of more radical reform that was anticipated there. I'm sure members are aware that in Scotland, however, where gender recognition is a devolved policy, they did proceed with an act, and that act went through the full statutory consultation and committee stage in Scotland and was signed off by the Scottish Parliament, but royal assent was withheld by the British government. They employed a Section 34 order under their legislation under the Scottish Act, and obviously it was challenged by the Scottish government, but the court in Scotland ruled against them, and my understanding is they have decided not to appeal. So at the moment that is in a state of flux in Scotland as well. In this jurisdiction, obviously we've been looking at this in a period of time where ministers largely haven't been in place, and because it's such a politically controversial and sensitive area, it's been difficult to make much by way of substantive progress. However, the previous minister, Conor Murphy, did wish to get some further information in this and commissioned a research report which was undertaken by a team from Queen's University Belfast, and they produced a report that was produced to the department in the summer of 2022. And that's quite a wide-ranging report in relation to the issue of gender recognition, although it doesn't touch upon other broader issues like...
It's Dr. Latu's report?
That's correct, yes. So that's essentially where we are with that. We have that report there, which was designed to inform future policy in this space. But to date, because we've had other priorities which have gone to the Minister in relation to things like marriage and civil partnership and the piece on defamation, we haven't fully yet explored with the Minister what her policy intentions are in relation to gender recognition reform.
Was there any, so there is a sexual orientation strategy was commissioned in the previous mandate. I don't think the strategy's been published yet. Was any work done or commissioned via that panel on gender recognition, or was there any consultation with your team from that side?
Martin, you might be able to better put. My understanding is it wasn't specific, but
it's called sexual orientation strategy, but it covered more broadly LGBTQIA issues more broadly, not just sexual orientation, I should say.
The research was commissioned principally in the initiative of the Minister.
This is the Latu report commissioned by
the Latu report, to inform policy decisions, but we did liaise with colleagues in the Department for Communities. I think that sexual orientation strategy began in former OFMDFM and then moved during a redistribution of OFMDFM functions. It moved to the Department for Communities, so it's with the Department for Communities now. They were certainly interested in the report and they received a copy of it. It was to inform their wider sexual orientation strategy and their gender equality strategy too.
We have responsibility for gender recognition principally because of the interface with the registration system and GRO. Yeah. It's actually, our focus is, I'd be loath to use the word narrow, but in the terms of the broader debate around gender, it is quite narrow.
Yeah. And of course, obviously, you would presumably have to, were there to be legislation, you would need to draw on expertise from other departments, presumably including communities and health and elsewhere.
Yes, we would. There is a cross-cutting element to this.
But just to move on to other things, so the minute in terms of gender recognition reform, where it is that there has been a report commissioned, but policy hasn't. A report was commissioned by a previous minister, but there's no executive agreement to proceed with any particular policy.
That's correct.
Okay. Now, just to go back to on defamation law, so we are going to get the previous act was passed in 2022. One of the things that emerged in deliberations around the defamation then bill now act was that it was quite difficult to establish solid information on the operation of the libel defamation law regime here, because so few cases actually proceeded to court. There have been more reports of court proceedings involving defamation law in the last sort of 6 months, year. Is that evidence of the fact that the Defamation Act 2022 means that are there now more cases proceeding to court than there were?
I don't think that we can make that linkage with the recent cases that you've referred. All of the evidence we got in the stakeholder engagement exercise tended to be of the view that it was much too early to determine what the impact of the 2022 Act is or is likely to be, other than most people supported the fact that there'd been incremental reform, and others were critical that it hadn't gone far enough. And you'll recall the debates which this committee, the former committee had, and the Assembly had around things like serious harm and other things like that. But I don't think we can make the connection that there's been some recent cases to show that the 2022 Act is the catalyst for this, because it's more than likely. In fact, it's almost certain that those cases emanated before the 2022 Act was in force, and indeed drew the judgments in some of the more high-profile cases tended to draw on themes which would have been prevalent before the 22 Act came into force.
Okay, so things like the move towards the assumption in favour of jury trials was
that won't have really filtered through totally yet
because of the time it takes for these things.
No, it won't. And I think that was. I mean, we met with the bill sponsor, Mike Nesbitt, during the engagement exercise, and I think he frankly accepted that 2 years wasn't going to be long enough to really get a clear determination that to see how the Act is working. And I think the experience, certainly in England and Wales, following their equivalent legislation in 2013, was it took maybe 3, 4, 5 years before there was a theme that could be developed to determine how the Act.
Case law basically became established.
Case law and other evidence.
More anecdotal of stuff that doesn't proceed to becoming case law because it's settled or whatever. Just so clearly, you've gathered anecdotal evidence, I presume, from practitioners and others. Is there a some of the practitioners or certain practitioners were of the view that who were more sceptical or opposed even to this legislation, indicated a belief that it would radically. I suppose the argument was broadly that it was. I'm not sure how I would distill the criticism of the bill. Has there been any? I mean, have those types of criticisms been vindicated in any way so far as you could see around the?
No, I don't think they have, and again for similar reasons. I mean, it's simply too early really to tell whether those criticisms will be borne out or not. But I think there's a general acceptance that the presumption of jury trials and its removal has been a step forward in defamation law. To what extent, or on the other side of the coin, to what damage that causes, I think will not really be properly borne out for a number of years yet, as cases that started off post 2022 go through the system, and of those only a very tiny fraction will ever elicit a judgment that will be worthy of discussion. We really only get judgments in what are known as hard cases, and I don't think there has been any of those to date that we can draw upon to fully understand how the 2022 Act has made a difference.
Would one of the potential outcomes be that there are that there may be a greater quantum of judgments because respondents are more likely to allow cases to go to court because they feel that the regime is somewhat more or somewhat less weighted in favour of plaintiffs, to put it directly. So there are more cases that are more likely to go to.
I mean, that's an entirely plausible explanation at this stage, yes.
Yep. Okay. Would any colleagues like to come in? Diane Forsyth, Deputy Chair, first of all, and obviously indicate anyone else who'd like wishes to come in.
Thank you, Chair, and thanks very much for being here again today. I want to focus on the defamation piece, and specifically your paragraph there on online defamation. You say it's new and a significant issue. When you say significant, what sort of scale are you talking about?
I'll pass over to Martin. Martin's been dealing with online defamation.
It's significant simply in the fact that most people we talked to mentioned it, and when we looked at commentary, it was prominent in that commentary. Most people who talk about defamation law say that online publication has created a whole new situation with regard to defamation. So it's a new situation that creates new challenges. It's significant in that sense.
And I look forward to seeing the detail coming through in the weeks ahead. But just on the paragraph there, my reading of it is significant, but it's not going to be taken forward within this.
Can I ask right? What paragraph that
Sorry,
is?
it's the defamation section. What page am I on here? Sorry, the bottom paragraph in it. It's page 122 in our pack.
Ah, okay. It's not numbered on your section?
That's my,
our brief,
that's my brief, yeah.
Well, yeah, so just in reference to the online, so just to expand on it, so basically, we're facing another election campaign, and I very much see this as a tactic coming up, being a victim of this type of behaviour of the past, perhaps conflict of interest, if you want to call it that, to declare, but I'm just interested in...
I think we don't have to declare that one.
But it's just, from my own experience, it was very much the case whenever I suffered a lot of online abuse, what I would consider defamation. The police reports were that the law is nowhere near sophisticated enough to deal with the type of things that are coming through online. So I was just wondering how advanced that is. Do you feel that there needs to be something accelerated through to make sure that the legislation's actually reflecting the behaviours online in this?
I think there's probably going to be a distinction made here between what you would describe as defamation and online abuse. And I think where the police would generally not become involved in a civil matter like defamation, but where they do come involved is in the example that you provided there, where there is online abuse. And I think obviously that aspect of it is way outside our remit. We are approaching this from the law of tort, and defamation is a tort. I don't think it's right to say that we would argue that nothing needs to be done in relation to online defamation, but there are certainly, even within the existing statutory provisions, there are mechanisms within which online defamation can be dealt with properly. Online abuse is a different thing, and I fully understand and appreciate that that is an important aspect.
And I appreciate that, but I was just wondering then what the link would be in terms of, is there somewhere that you feel that you should be joining up with the Department of Justice on it? Because again, whenever I took forward a case of online defamation, what was put to me was the quantification of the burden to prove what I lost was so high in my situation. Because I won my seat in the Assembly, I didn't lose anything because of the comments posted online about me, so I didn't lose anything, so I was offered no way forward. So I do feel that this is relevant here, so because there was this gap, this was my experience here. So again, just to come back to the online defamation where something is published, is the law, do you feel it's advanced enough to capture what we would be facing here?
I think we would be frank enough to say that there's certainly room for improvement in this space. Online defamation was one of the themes that was raised during the consideration of the Act in 2022. What I would say is that the provisions that were put in place in the bill as drafted by Mike Nesbitt were rejected by the Assembly. And I mean, as officials, it's obviously difficult for us then to make an alternative case so soon after the Assembly has rejected provisions which were designed in the main to try and deal with certain aspects of online defamation. The Section 5 and Section 10 of the English Act were rejected by the Assembly. Now, that's not to say there aren't other methods there that can be used in order to do so, but in terms of legislative interventions, I think we have to be frank enough to take a view that the 2022 Act is a very recent piece of legislation in which the Assembly quite clearly had options and took certain options in that space. And in the face of quite as you can have heard already, quite a significant programme of law reform projects, we might find it difficult with our existing resources to devote the amount of time that would be required to really get to the heart of things like online defamation. And it wouldn't be online defamation in a silo, it would be online defamation taken in with other aspects of defamation law that have come up during our engagement exercise, which could form ultimately a package of reforms. But I think realistically they're going to be a longer term piece of work, and that it's unlikely that during this mandate, for example, we would be in a position to bring forward further defamation legislation.
No, and it just it is important to flag because just how rapid the things are, and then whenever the legislation is very much referring to published material, and published is in paper, and there's a loophole there, and as we would be looking at it going forward, would you say there would be two offences there in terms of the person who would post the online defamation and the platform that allows it to remain?
Gordon, do you want to come in on that point particularly?
Well, certainly we've identified through our research a number of possibilities for policy. There have been successful prosecutions of people for defamatory material posted online. The difficulty has always been things like identifying the person who posted. People will post pseudonymously or anonymously, and then getting the provider of the website or the platform to name that person, if they can do that, which is not always straightforward. It's often more a technical problem of trying to identify the person who posted the defamatory material. If that person can be identified, then a conventional Defamation Act action can follow.
Thank you, and I appreciate the complexity of it, and I think in terms of that, it's something I know the Justice Minister, I was involved with working with her previously on under the online abuse piece on the platforms needing to verify people's identities before actually posting. So I think that the two things go hand in hand, and appreciate that. Thank you. Thanks, Chair.
Okay, so Nicola Brogan.
Thank you, Chair, and thank you both for coming in here this afternoon. I have a couple of questions on the gender recognition piece. You said that England and Wales had reviewed their Gender Recognition Act and had made some recommendations or suggestions for reforms. Could you give me some detail on what those were?
Well, when I say they gave recommendations for reform, there was a very detailed review of the Act in England and Wales during, I think, 2017-18, that sort of time frame. And there was an understanding, certainly at official level, that the direction of travel would lead to self-recognition. But that
self-identification.
Effectively, yes. So in other words, not going down the medical route for the gender recognition certificate. But political decisions then overtook that, and the policy was effectively shelved in England and Wales.
Is that really the big change from what we have now, is moving to maybe a self-identification route instead? Is that what you'd be looking at?
Well, I mean, that's one of the policy options available in this jurisdiction.
Yeah.
There are obviously a number of fairly high hurdles that would have to be overcome before that would reach a legislative outcome in this jurisdiction, but it's certainly a policy option that is available. And of course, in the South, they have a self-recognition system there, and we've taken account of reforms in that jurisdiction, as well as the work that has been undertaken in Scotland, and as well as the material that comes from England and Wales, and indeed globally, where there's been a number of countries throughout the world who've made changes to their gender recognition law both ways. Actually, some have become harsher, others have taken a more lenient approach.
Let me open it to my next question. Was for that report that Conor Murphy had commissioned with Queen's, have they taken into consideration how the South works and their self-identification? And maybe, because I see on your report there's I think 900 people in the South have used their route since 2015. I think there's 75 in the North.
One has to remember, of course, that before 2015 in the South, there was no facility whatsoever to change gender in this way, and there was most likely a considerable volume in the first couple of years when the legislation came into effect of people who had been waiting for the legislation, coupled with obviously a greater population. But I don't think the figures are that much skewed in that sense.
I assume people have the opportunity to change their minds as well. Well,
that's part of the policy, one of the policy issues. There was considerable debate, particularly in Scotland, around that, and they in fact amended their legislation there in relation to the bill as initially drafted was quite flexible in relation to that, but in response to certain concerns it became less so.
Final question on that is just about your engagement, the department's engagement with stakeholders and different organisations who are obviously concerned with that and are passionate about it. What's the engagement been like, and have they been? Do you feel like they've been satisfied with your cooperation with them?
Well, I mean, it's been a while since, to be frank, it has been a while since we've met with stakeholders within the transgender community, although we have had meetings with them in the past, and indeed the previous minister met with them as well. Of course, we're more than happy to re-establish those links once we get a sense of what direction of travel this is going to take.
That's helpful, thank you. And I just want to touch upon the no-fault divorce, because we did bring the motion to the Assembly 2 weeks ago, and it was passed, and I know Kiva as Minister has supported it as well, and has given indication that she would like to bring legislative change in that matter. Have you any update on that, or where it might sit there?
Well, only to the extent that, as the Minister said during the motion, that she has asked us to undertake some preliminary work and to start engagement with those who can make a useful contribution to the debate on no-fault divorce. And I mentioned that we have a new member of staff joining us this week, and I'm hopeful that with that resource we'll be able to commence that work very quickly and to start scoping out some of the policy options around no-fault divorce with a view to bringing those back to the Minister later this year.
Okay, thank you for that. Thank you, Chair.
Just to confirm, the policy options on no-fault divorce are being scoped
this year.
To be scoped this year, but we're unlikely to see legislation introduced this year.
No, I think we have to be realistic, and I think if there is legislation, it will be later in this mandate, most likely in the year 3. We already have a very significantly compressed mandate and a very large number of bills, and it's not just from our perspective our own priorities, but we also have to factor in the priorities of the wider executive and the resources, for example, of OLC, and we've already got our marriage and civil partnership bill there as our principal bill for 2025, and I think at best it would need to be a 2026 bill.
Okay. Paul Frew.
Yes, thank you. Could I bring you on to the SLAP issue? I see that there was a bill going through the House of Commons, and I suspect that has fallen now with regards to the calling of the election. Have you studied that bill? It's a private member's bill.
We have, and we've also engaged with MOJ colleagues on it, and indeed Scottish colleagues, and also Department of Justice colleagues. SLAPs, just to put it into its context, is much wider than simply defamation. The SLAPs legislation in England and Wales, or what was proposed in England and Wales through the private members bill there, would have covered all sorts of actions, not just defamation, but privacy and environmental aspects and other aspects. And essentially SLAPs are court processes and how the court system deals with vexatious or intimidating types of claims, which are set out by plaintiffs in a whole range of different cases. And therefore, it's our initial assessment that any legislative reform in SLAPs would need to be taken forward probably on a wider basis in this jurisdiction, and probably led by justice. We would obviously want to have an iron in that fire in relation to how there's an interface with defamation law, but that, I think, is probably where the height of our remit would allow us to get to. But we're certainly very interested in it, and we're keeping a very careful eye on developments in England and Wales, and also in the south, where there's some linkage in there in terms of their general scheme for a defamation bill, where SLAPs are mentioned in that as well, because they obviously have, in the south, they have got that European directive type of dynamic going on as well. So it's an area that is very much at the forefront of our work in relation to the defamation piece.
This is probably more a justice-related department question, Justice Department-related question, I should say. Are we clear that, and again, if you don't know this, that's fine, but are we clear that the role of the court and the judicial system is the same, so that we could actually put a dismissal mechanism within that process?
Well, what I would say is that there are currently, under rules of court, there are mechanisms to do that. I think that's been very clearly highlighted in recent cases in this, where the courts do have the powers. Where I think the SLAPs debate is heading in England and Wales is that they want to really set that out on a statutory basis and reinforce the message that, and there is a kind of different context there, because I think SLAPs in that jurisdiction have been driven by very, very wealthy external people coming in and using England and Wales as the focal point to bring forward a case which they're used to intimidate whoever in that jurisdiction. We haven't really seen that here, but some of the themes that come from that bill are, I think, relevant to this jurisdiction, and there's certainly things we want to keep an eye on.
Talks about a cost protection scheme which will be created to protect defendants like journalists, which is probably relative to the experience that we've had here over the last year.
Did you say costs protection?
Yes, a cost protection scheme which basically allows the court not to allow the defendants to pay basically the legal costs of the claimants' costs. Is there a cost bearing, or would there be a cost bearing then on the government with regards to that, or have you?
Well, if there is, that would be a matter for the Department of Justice, because that would be a legal aid issue, and at the moment legal aid is not granted for defamation cases.
Yes, so it could open that whole sphere of things up there too. Okay, very interesting, thank you.
Okay, Deirdre Hardy.
Just the civil registration in Irish, obviously it's an NDNA commitment, and I know the Minister met with Conroy na Gaeilge a while ago there, so it's just to see how that's progressing.
Well, sadly, not sadly, I suppose, but that's a matter for my colleagues in GRO. They lead on all of those aspects. The one exception, I think, is maybe in relation to wills, where the department has an interest in the substantive law relating to wills, and I know there's quite an ongoing debate at the moment around the validity of wills being made in Irish. Now, our role in that is relatively peripheral from my own office's perspective, because the substantive law in relation to wills does not prevent a will being made in Irish or indeed any other language, but the difficulty relates to their recognition when it gets into the court system.
Okay, and the other issue was just you touched on in your paper in terms of lack of expertise in some areas of civil law, and particularly around land law, for example. I know you touched on it here in terms of you getting another staff member who's joining soon, and obviously the other issues around gender recognition and maybe research and stuff that would need to be done to inform policy then to create legislation. So it's just to see what's being done to kind of overcome some of those issues. And are there certain areas around civil or land law that you would like to prioritise in the time ahead that resource then could be directed to?
If I had an appropriate level of resource, there are any number of law reform projects that I would like to see taken forward. Land law is a massive area of work which requires really, really technical expertise, and you need to find the right type of people to do that work, and unfortunately my office hasn't had that type of expertise for many years now. There are a couple of areas there in particular around shared property management, for example, the law relating to apartments and other aspects of land law that I think in an ideal world we would hope to make progress on. I am, and we are in fact at even up to permanent secretary level setting out our areas of work and what type of resource we might need in order to progress those, and we hope that that will go for attention to the Minister quite soon, and after that we might have a better sense of what is achievable, not just in the remainder of this mandate where there are other factors other than simply resources that will maybe stymie the amount of legislation we can bring forward, but longer term where we would hope to make progress on a number of fronts.
Just a bit on I suppose the apartment one, because I'm seeing that increasing even just in Belfast in terms of cases coming forward and a lack of clarity at times. So it's just to see, are you getting the same view and any engagement with DFC and stuff around those issues as well?
Well, DFC obviously have an interest in relation to the private rented sector and the sort of housing piece. This department has an interest in relation to land law and the substantive land law. The lines are a bit blurred at times, but at the moment, we try to do as much as we can in terms of providing advice in that. But in terms of legislative reform, we simply don't have the tools at the moment to do that.
Your view, sorry, just last question, is that there could be improvement in those areas. There's gaps at the moment then?
I think that's absolutely the case, yes.
Yeah. Okay, thank you.
Okay. Anybody else wish to come in at this point? Owen, tell us.
I just have one question, Chair, and Michael, you touched on it in terms of the gender recognition questions that Nicola asked, and that is that obviously your remit is quite narrow in terms of the GRC, and it often gets tangled up in the wider debate and the health issues and all of those things. I guess just for absolute clarity, it'd be helpful, I guess, if you could outline what a gender recognition certificate actually is and what rights that does and doesn't confer to the individuals who receive them.
Okay, well, I mean, a gender recognition certificate is basically evidence that a person's gender has changed, either from male to female or female to male, different from their birth certificate. And what it entitles them effectively to do is then to change their birth certificate to the gender that they have changed to, and that effectively then allows them to proceed in the gender that they've chosen to change to from birth.
And in terms of, rights that confers, as I understand it, it doesn't actually have a significant impact in terms of, for example, access to single-sex spaces and all of those things. That's dealt with under separate legislation.
I mean, that's broadly speaking right, and sometimes the debate around gender recognition can get quite toxic because people conflate the two issues, and usually mistakenly conflate the two issues. And it's obviously a very sensitive area, but broadly speaking, your analysis is right.
No, that's helpful. Thank you.
I think it's important to say GRC is a bureaucratic thing that makes people's lives easier rather than rather than some of the other claims made about it. Steve Aiken.
Yeah, no, it's just about something else in your briefing. The Singapore Convention. Look, I know the Singapore Convention and the rest of the UK signed up to it, and I think we will be asked as an assembly to ratify it. Don't we have to?
I'll pass that over to Martin.
There's a process of ratification. I think it goes to First and Deputy First Minister as an international agreement, and then they take input from other ministers with relevant political responsibilities or policy responsibilities.
I just stand with our rules and obligations under the Windsor framework and under the requirement for the ECJ for trade issues, because it is a trade issue piece.
I haven't looked in that level of detail, but my sense of it is that it is so niche it will not.
Yeah, it's just something I was reading through. It was international commercial disputes have been resolved through mediation. There's a particular process. It's designed to make sure you don't go down the line of having to go all the way down, that would eventually end up in sort of one of the trade courts, or in our case, because we're in this dual market access, it would potentially go down the ECJ route. Mike, I just want to know, I'm genuinely interested, where does this sit in relation to the Windsor framework, the Singapore Convention? Could somebody, I don't want to answer that, could somebody actually find that out for us and let the committee know? And I know it's a speculative one, but it's I spend most of my life in the Windsor framework thinking, I wish I would asked that question earlier.
I don't think it's been raised in any meetings we've had with colleagues in MOJ, and one would have expected if there was an issue there, they would have flagged it long before now. Because
regrettably, no, that doesn't work that way.
Ultimately, I think ratification is going to, or the implementation of this is going to proceed on a UK-wide basis.
Yeah.
As opposed to different devolved administrations taking forward separate statutory instruments, but because it's something we can certainly.
Just in your own brief, you have the bit about the first line is the Singapore Convention applies through international commerce, and then the final line is the EU has its own mediation directive and applies across all member states, which applied to the UK prior to the Brexit. Also means it applies to Northern Ireland and not to the EU. So
I think there's a distinction here to be made between goods and services.
Yeah, I just wouldn't mind just a quick note. And
we can just go through the committee. So is your request that we have an update from the department on whether there is any interaction? I think it would be. I mean, if you just give us a. Rather, we're not asking for a briefing paper, but if there's any, paragraph.
I'm not. I don't want to fill.
Yeah, it'll go to the DALO to ask for any clarification, rather than to. I don't want your new starter to be watching this, and if she's watching, it'll be.
It just shows you why she read the brief as well. So there you go.
Okay. If no other members have indicated that they wish to ask a question, so thank you very much, Michael and Martin. That's been a really useful. Briefing session. We obviously we've taken a note there where we'd like updates. Obviously, we welcome the fact that the defamation, law review is being published, or is going to be laid, it sounds like, before recess, and also that we will be kept abreast of any developments in terms of commissioned work or policy intention around gender recognition reform. and obviously we're going to be keeping we'll be ready to scrutinise and do any scrutiny that's necessary around the marriage law legislation, and indeed anything else that comes up. So for now, thank you very much for your time.
Thank you very much. Thank you.
Thank you. So members, I think it may be that given it came up and there's a bit of background work to be done, I would suggest that possibly for the autumn time that we could look at a briefing as part of our forward work work. I'm not sure, is it scheduled, Dr. Latry? Is she scheduled before?
We haven't got a time scale in. Her report's fallen under our stakeholder TBC, so if members are content, we move ahead on that one.
So the proposal would be that we take evidence at some point in the months ahead, probably not now before recess because it's a relatively tight timeline, but on her gender recognition report. She's the QUB academic who's done that work. If people are content, are there any other follow-up actions? I think we have a list of things we wanted updated on.
We have clarifications.
Okay,
to
we'll go via the dialogue. Okay, thank you. Thank you for that. The next item is the next item is Agenda 8, which is correspondence. And I have a pleasant surprise for everybody, which is there is no correspondence. So where people are too busy with the election and anything, the European Championships and whatever else, to worry about corresponding with the Finance Committee. Agenda item 9 is the draft forward work programme, and the clerk will give us an update on that.
So, Chair, you'd mentioned the briefing with Hawks. We provisionally got the 26th of June for that. They'll confirm with us hopefully next week that their diary secretary has already spoken to us on that one. The business plan briefing we had planned for next week. Business plan hasn't made it through the Departmental board yet, and then it'll go to the Minister after that. So what we're suggesting is we slide that one down to the 19th of June, as the 12th is already fairly packed. So it would move from next week to the 5th. And then we'd been holding two dates around main estimates, the 19th and the 26th. But we're going to go for the 19th because the 26th has now become fairly crowded. And the building regulations that were scheduled for the 19th, we're going to move to the 26th. And that's part of why the 26th was so crowded. So it's complex, but everything that's there will now just move slightly if members are content with that.
Yeah.
Okay, people are content?
Yeah.
The forward work programme, I assume everyone's content. The forward work programme will be published on our committee webpage. Okay. Agenda item 10 is any other business. Do any members have any other business they wish to raise? No. Okay. Agenda item 11 is date, time and place of next meeting. The next meeting is scheduled for this room, room 21, Wednesday 5th of June at 2 p.m. If people are content, I will adjourn the meeting. The meeting is now adjourned.
Committee Room 21. Sound. 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 Committee Room 21. Sound.